Good afternoon. My name is Jim Wabandato, and I'm a program officer at the Indian Land Tenure Foundation. We are working on putting together a series of informational sessions to help Indian landowners better understand what the processes might look like with the federal government, how to provide tools that will help them in managing their Indian land, and along the way, hopefully your questions and your interest will help us better serve your needs. Today I will be moderating the session on wills and estate plans. I've got two wonderful estate planning attorneys that will help us. As you may have heard, and I will kind of highlight this for folks, today's meeting is being recorded, so any details you share will be saved within the recording, so please be conscious of that. But I would like you to feel free to ask your questions either by raising your hand and then we can find a space to fit you in, or by placing your questions in the comments section and I can address them to our two wonderful guests. Before I kind of move on to the affairs of this, I do want to share at the beginning and then perhaps at the end that on June 22nd, next month, we will be doing another town hall, and that one will be addressing appraisals. So having introduced myself, today we have Heidi Dropnick from Swanson, Dropnick, and Telsey. She's based in the Twin Cities of Minnesota and has been a partner with us at the Indian Land Tenure Foundation for quite a few years. I think, I know for a fact she predates my time and tenure at ILTF. We're also joined by Emily Oleftorakis. I think I got that right this time. And Emily is an attorney in Oklahoma. She works in providing educational instruction to law students at the Oklahoma City University School of Law. I'll go with Heidi first, based on alphabetical order. If you would feel free, please tell us about yourself and your interest in wills and estate planning for Indians. Oh, you're on mute.
Oh, thank you, Jim, very much. It certainly is a privilege and an honor to be here today. As Jim has stated, our law firm, Swanson, Dropnick, and Telsey, has been affiliated with Indian Land Tenure for, I was looking at it, it's over 10 years now that we've been doing wills. And so my name is Heidi Dropnick. I'm an attorney with the Swanson, Dropnick, and Telsey, and we're three Native American women. I'm enrolled at Boys Fort, and one of my partners is enrolled at Brothertown and the other in White Earth. We ran a project called the Minnesota Indian Estate Planning Project for many years, and through that process, we, in the state of Minnesota and Wisconsin, wrote and finalized approximately 450 to 500 wills, and we're still doing, that work. We haven't done as much lately, but that's kind of my background. I've practiced in Indian law. Our firm represents individual Indians as opposed to, other firms. Our specialty is to represent Indian individuals. So we do a lot of, so this fit very well within the type of law that we practiced, and we've been practicing for many, many years. I was going to mention the years, but I think it's like older than some of you. So, but it is a privilege and an honor to be associated with the Indian Land Tenure Foundation. And thank you, Jim, for asking me to be part of the panel today. Thank you.
Wonderful. Thank you, Heidi. And Emily?
Hi, Jim. Yes, I will echo Heidi and thank you for asking me to participate in this panel this afternoon. My name is Emily Oleftorakis. I am an attorney in Oklahoma City, both in private practice as well as a clinical adjunct professor at the Oklahoma City University School of Law. In my private practice, I work primarily in estate planning and probate, post-death administration. Started out at a bigger firm in Oklahoma City, where I worked with some of the best estate planning attorneys in the state of Oklahoma. Moved on to do a little bit of oil and gas title work, which obviously ties in quite a bit of the trust property and Indian property that we all work with and that many of our clients own. And then broke off and started my own practice where, like I said, primarily I do estate planning and probate, some other sort of small business work and things of that nature. The clinic that I teach at the university is an American Indian Wills clinic, and that is how I met Jim. We are a grant-funded clinic, so we do a lot of work with the Indian Land Tenure Foundation. The clinic offers pro bono legal estate planning services to Native Americans in Oklahoma that own trust and restricted property. It is a student run clinic, so clients get to work one-on-one with an individual student who will prepare estate plans, any other corresponding documents that are necessary to fulfill the wishes of the client for all post-death related administration. I am happy to be here today. Hopefully we have a good conversation. And again, thanks so much, Jim, for inviting me.
You're welcome. I'll throw out the first question so that way we kind of have a place to start. I'm wondering if either or both of you would address what the difference is between an Indian will and any other will.
I guess I will start because it's an easy one, and maybe Emily can take the harder questions. No, just kidding. So an Indian will has, why is probate or estate planning different for Indians? There is a act that was passed by Congress, the American Indian Probate Reform Act, and it is governing how trust property is distributed when an Indian landowner passes on. And so APRA, as it's called, is meant to confront the problems of fractionated trust land by preventing further divisions. And so it places limitations on who can inherit interest in trust land and how how that is happening. So for Indian people, there are a will, or I should back up that. For an Indian individual, the American Indian Probate Reform Act will provide rules in the event the individual dies without a will, and so that's why it's very important for a Indian owner of trust land to have a will that governs these provisions, or there could be unintended consequences. As in all things Indian, it's more complicated. The probate process is more complicated for Indians than for non-Indians because you may have three separate sovereigns. The tribal sovereign that would probate some assets owned, the state, and then the federal. And the federal deals with the trust land. And so there's a separate and distinct federal probate process to deal with distributing the trust land. So I think I'll end that there, and hopefully I answered that question.
Oh, Jim, I think you're muted now.
I did, thank you. How long does it take to do a will? And how can I get ready to do it with somebody or get it taken care of?
So I can jump in on this one, and we may, and I'm going to come at this from the perspective of our clinic, since our main clientele are Indians that own trust and restricted property governed by APRA, like Heidi just discussed. Generally speaking, that's kind of a hard question. How long does it take to do a will? Because in my experience, it kind of depends on the client and how quickly they are willing to provide the necessary information to get that document executed. So sort of steps that we usually take, and this has kind of become more in line with practice during the pandemic. Most of our information gathering is done via phone. Our students will contact the clients and do an intake. Generally, that takes anywhere from 30 minutes to an hour, kind of depending on the complexity of that particular client's family situation, questions they may have concerning the process and what they're wanting to do with their property. Once we gather the information, it takes our students, a few days up to a week to get some documents drafted. They work with the client to fill any gaps, find missing information, and then we schedule a time for that client to either come to the law school to execute their documents, or we often have planned service dates where we go out into the communities and have set dates where clients can come somewhere a little more local to them and make that trip easier. I would say for the most organized clients, your will can be done just as quickly as you want it to be done. It really is all dependent on how quickly we can get the necessary information, put it together, and get those documents executed.
I think that I would add to that, our process is substantially similar. We have developed a process where we actually extract information from clients. They generally know what they want, but they don't know how to organize it in a manner that, it's a little overwhelming. And so part of our process is to ask a lot of questions, and through that are able to turn around a will fairly quickly. It's as quick as the client wants it to be. In our process, we have been fortunate enough to develop a relationship with the BIA and the trust department to get some direct information about ownership of trust property. And so that's very, very helpful in the turnaround time. If we did not have that process, it could take much, much longer. So that's been a very valuable partnership to have with Indian Land Tenure to open up that door to be able to, figure that out rather than rely on the client to dig around for their ITI reports or their land records. And maybe Emily has a little more to add to that, because I know that there's a significantly different process that in Oklahoma I have learned than we do. In Minnesota and the surrounding states, our land is highly, highly fractionated, and so we're generally dealing with very small amounts. It's very rare that we have something over 5%, and if there's one, it's only one tract of many that are very, very small.
Yeah, we have, it's a mix. We've got quite a few clients who have very small fractional interests. We've got some that have the larger interests. And we have a similar process where we get, consent forms from the client, direct those over to the BIA, and are able to get those ITIs so that the clients don't have to. We often too, a lot of our clients are very familiar with the BIA, and they bring us their ITIs with them when they come in for appointments. And so again, we have access to get that information. We also have clients that bring it to us. Absolutely not necessary, since we can access it. But if they have it and they want to bring it and that helps expedite the process, they are certainly welcome to do that.
In talking about that, I know that wills has been a issue that people have been concerned about during the pandemic. As we're starting to come out of it, it sounds like the Bureau of Indian Affairs has struggled to get information to landowners. Are you experiencing that yourselves? And do you expect that should get better as everyone starts to emerge from these shutdowns?
Yes, I hope that it will get better. I know our BIAs have been closed, and so yes, it has been really difficult. We've had to go to the offices outside of the state of Oklahoma to get information, and so yes, I'm hoping as they start to open back up that process will become again more streamlined.
Thank you. Wondering, how expensive is it to get a will written? For an Indian landowner? I mean, what should we expect Is that something that is going to be $400 or $500, $1,500? Is there something that people should prepare for? And I ask this, also, the Indian Land Tenure Foundation has provided resources for you guys to write wills for free to Indian landowners, and for income qualified landowners, they may be able to obtain services for estate planning from the Legal Service Corporation funded organization, and every state does have one of those as well.
So I'll address, you know, kind of, that's a multi, you know, level question. So our program, the Indian, you know, the program we ran with the Indian Land Tenure Foundation, Minnesota Indian Estate Planning Project, was fully funded by the ILTF. And because of that, it's why we wrote so many wills in over the course of the past 10 years. And so we offered services for free. However, if an individual was to come in and need a will from a private attorneys, you know, you're looking at somewhere between probably $500 to $700 for them to be able to write that will. And so, you know, a lot of Indian landowners, even, or Indian individuals, don't necessarily have that complex estate planning. And if they do, then it of course will be more expensive. But I don't believe that. I think there's one legal services that provides estate planning in Minnesota, but I don't think that there really is any other service besides ILTF that is able to do that. You know, so that's kind of answer from my perspective. I hope that answered your question, Jim.
Well, and it does. Let me kind of provide for the rest of the audience that Heidi, as a partner in her firm, it works in private practice, and so she is going to be under different restrictions than, say, Emily at the law school, but Emily has also private practice as well, so she may be able to provide additional insight into how Indians can afford or might get access to getting wills written as well.
Sure. As I said, kind of initially, we are a grant funded clinic. So similar to what Heidi was discussing, we are able and very fortunate enough to offer pro bono free estate planning services to our clients. So our clients never have to pay, they never have to worry about doing that. And that is something that we consistently are able to do each semester. And, you know, there are times where we have clients that come in, and again, as Heidi said, most of our clients, their estates are fairly simple. They don't need any additional or more complex planning than what we offer in the clinic. But if there is an occasion that we have some clients that come in and we think they would maybe benefit from, you know, a private attorney reviewing their estate and taking a look at both the Indian and non-Indian property and kind of helping them with that, for just kind of generally speaking, it's probably similar to what Heidi said, anywhere from $500 to $700. Most of the time, attorneys around in Oklahoma are offering estate planning packages that are going to include additional documents to just the will. But I would estimate anywhere from $500 to $700. We also have other services here in Oklahoma. We've got the Oklahoma Indian Legal Services, or OILS. They are also a lower income legal service provider, and they do estate planning services. I do know they have an income limit. So, you know, if for some reason, you know, we're a school clinic, so we operate on a semester basis, meaning we only have, you know, a few months in the fall and a few months in the spring. We don't work during the winter break. We don't work during the summer break. So we are often referring clients who maybe we can't get to or don't have the time or the ability to get to them as quickly as they need to be. We refer them over to OILS, and OILS can help them out as well.
Thank you. Now, both of you had kind of mentioned in your comment, in your answer, I should say, other estate planning documents. What are some of the pieces that an Indian landowner isn't necessarily going to think about, but should be aware of when they're putting together what we would in our business call an estate plan, which is more than just having your will in place.
I can take the lead on this one, and I'll let Heidi kind of supplement what all they do in her practice. But what we're doing is we are providing clients with a will. So that legal document that is going to dispose of the Indian real property as well as any other property that the client owns at their death. That's the document that is going to govern the probate process and govern descent and distribution of the client's property. In addition, we offer, we don't, it's at the client's option. If they would like, we do powers of attorney, which is a document that will allow someone to act on the behalf of the client if they are to become incapacitated for any reason. And we also encourage clients to do advanced directives, or they're often called living wills. So medical decision making at certain end stage conditions, or when there is some kind of medical condition going on and the client cannot make those decisions for themselves. So in addition to, the document that governs who is going to get what after my death, we also encourage our clients to plan for situations and scenarios that may arise before their death, such as illness that prevents them from being able to make their own decisions.
We have experienced, to add to that, some other documents that we might have is if the individual is interested in a trust, that might be something that we would do. And a trust is, we're encountering them more, whether they're a separate document or within the will, to deal with sometimes a child with special needs and not being able to pass on property to them without them losing their benefits. And so you have to do special things to ensure that that doesn't happen. And so a trust may be a document within the will or outside the will may be appropriate in an individual, for an individual. Frequently in Minnesota, especially, we have some really unique leasehold issues, which is non-trust land, or it's trust land, but it's not, it's leased by the individual. So it's on the reservation and leased from the tribe. And those are very particular to the tribe, and the passage of those are not only very complicated, but because there has been no active probate, generally on probates of these leaseholds, you could be 2 or 3 generations away from the actual person who's on the lease. And so all of those complicating problems, we do have either documents or, bills of sale, different things that we may need to do to finalize or, to clarify the ownership of the house on top of the lease, or, where that might pass, or, so we do a lot of working with the land departments to try to, clear up any problems. So there's additional documents that might entail, and just kind of bringing that to everybody's attention, because every tribe is different and it is all very, very complicated. And so you want to try to address some of that stuff before you actually get to probate, because in probate, there aren't very easy answers for some of these. Like, for example, the house may have passed from the spouse, one spouse, like it may have held the lease, and and they pass away, and the remaining spouse may never have the lease, but may have a mortgage on the house. And so when that second spouse passes away, who actually has the lease, and where do you need to go to get it transferred? So it's like, a lot of individual issues that are going on with that. But additionally, frequently we have people who either own houses, more frequently have houses that are on the reservation and off the reservation. If you have off the reservation real estate, then you have some probate issues, state probate issues. And so there is something in Minnesota that's called a transfer on death deed. the transfer on death deed is a mechanism to avoid probate. If you have real estate off the reservation and you don't make some planning for it, then you'll end up in state probate proceedings, and that is, from my experience, especially with Indian folks, very complicated. You generally have a asset that might have a lot of value, a small mortgage, but it's very difficult because of all the players to probate. So I would encourage, you know, we're seeing more and more of that type of thing, needing that alternative to, you know, planning to make sure we're not ending up in the state probate. Federal probate is complicated enough for the trust property, so.
Yeah,
Thank you.
I'll just chime in really quickly. Oklahoma also has a similar transfer on death deed process that we can offer clients as well for off reservation property.
Can you address any of the differences that a landowner in Oklahoma might expect? I know that there are about 20 tribal communities that have their own federal probate law that the federal government will recognize. Many of those are in Oklahoma, and there is a different probate court of jurisdiction. Can you address some of that?
So you mean probates that are going to go through the tribal courts versus through the administrative forum? Is that what you're referring to?
As well as state courts.
Okay.
For the 5 tribes.
Oh, 5 tribes. Yes. Okay. So in Oklahoma, we've got we've got our trust property, and we also have 5 tribes restricted property. And so yes, there are tribes that have their own probate codes, and generally speaking, most of our clients that come to us, probates are still going to go through the BIA Federal Administrative Forum. However, for 5 tribes restricted property, that property is governed by and is probated in Oklahoma District Court, state court. So we've got, kind of a dual interests kind of competing here. So if you've got trust property, you have to look at and ensure that you are abiding by APRA laws and regulations. And simultaneously, if you are, doing a will for any non-Indian property, you've got to be sure you're complying with Oklahoma state law as well. For 5 tribes property, that's where we are doing wills that specifically, are governed by, and we ensure validity under Oklahoma state law and Oklahoma state statute. And those wills are going to just go through Oklahoma state probate like any other state probate case would proceed.
Let me turn toward a couple of more direct questions. One of the things that we'll hear people ask is, well, what should I do with this? Where should I keep my will? How do you respond to that? Or even who should I tell about my will?
So we often, we instruct our students once we have executed all of our documents. We are, a grant-funded clinic. So from semester to semester, we sometimes don't know if we're going to have the funding to be around the next semester. So we aren't able to keep anybody's documents. We don't keep copies of documents. We keep unsigned copies. So whenever our clients leave whatever location we're at where we've executed the documents, they leave with the only originals that exist. And so we give them to them in a little blue folder that's got a sticker that says, keep in a safe place. And generally we encourage clients to put them in a place where they keep other important documents, such as a fireproof safe, and make sure someone knows where it's at. So either a spouse, the person you've named as the executor, someone needs to know where it's at. We have encountered problems where clients have put their documents in a safe deposit box, and the only person that has their name on that account is the client themselves. And so we are We try to make sure that we tell clients if that's what you're going to do, because that's, often that's a good place, and where clients like to keep important documents, you need to be sure that somebody else's name is on that account, because if client passes away, their name is the only one on that account. We're going to have to get a court order to get into that safe deposit box. So usually we tell them, keep your documents in a safe place, safe deposit box, make sure somebody else's name is on it, and make sure somebody else knows where that will is at.
I would, we do the same thing, and I really concur with the safe deposit box. That is not a good option at all unless, and it's become an expensive option unless you have somebody else that has access to it. Otherwise, you end up going to probate. Despite all your planning, you go to probate just to get a hold of it. Frequently, we tell people in Minnesota, you can deposit for $15. You can deposit wills with the district court, not the tribal court, but the district court. And while I think that may be a good option, it's not a good option, I think, for Indian people, because Indian folks, we travel a lot and may not end up in the state of Minnesota. So I think the better option, what we advise, is go to Target and get one of those little lock boxes and stick it in there. Although we've had a lot of issues with, we similarly do not keep originals, not because we're not going to be here next quarter, but because people are mobile, and we don't know if we're going to be here in 15 years when people are going to need it, and what do you do with it? And so we give specific instructions, don't give, tell somebody else, tell your personal representative where they can find them if something happens to you. That's very important. Put them in a lockbox, put them somewhere where you're not going to put them with your mail and then misplace them. But, it's a challenge. I think it's a challenge keeping track of that stuff, especially people who move a lot or may be of lower economic means of having a separate place to keep that stuff. So we do keep copies. We do keep, and we put them electronically, and we have used them frequently. And so that affects the probate process if you have to admit it, but hopefully most of the time you're not going to need it. That's the hope.
Yeah, and I agree with Heidi. I think this is one of the biggest challenges that we experience is we get a lot of calls after loved ones have passed away asking, do we have copies or do we have the will? And we have to tell them no. And so we try really, really hard to encourage clients. Same thing, go to Ace Hardware, buy a safe deposit or a fireproof safe. Keep your documents somewhere and make sure somebody knows where they're at.
Now, one of the things that also is important, I think, to understand, I'm hoping either of you will address, what if my dad gives me a copy of his will, went to a copy machine and made me a copy? Is that okay?
Yeah, ideally, the probate court is going to want the original. It's the easiest to get admitted, and that's what they want. If the original is lost and all we have is a copy, then that will have to be sufficient. And like Heidi said, there are a few extra steps to confirm the validity. So yes, copies are okay so long as there is an understanding that the original is going to be what's needed ultimately.
Kind of tangential to writing the wills, what should I know or who can I talk to about the federal probate process? Because you've said it can be kind of hard to navigate. What are some of the things I should know?
I think that communication is the main thing. It starts, at least up north here, it starts with the land department of the tribe. And so contacting them and getting the will to them immediately is going to make the process go quicker, and much, much quicker. Instead of years, it may be months. So there are some people that I've seen, it's extraordinary when people cooperate, how fast the federal probate process actually is, because their main purpose is to, collect the information and decide the heirs. and then, you know, the BIA distributes after that. And so that process can be fairly quick if they get all the information quickly. So if the family can contact their land department, find the number if they need to provide the will to the local office, and if not the local office, the regional office, and if not the regional, then Office of Hearing and Appeals, which is the kind of probate court for the federal trust land.
Yeah, same thing in Oklahoma. Just get the information to your local BIA agency as quickly as possible. The faster you get information, the faster the process will begin.
Then they don't, it's particularly if there's a will, then they don't have to, you know, rummage around and try to locate, the will. You know, they will, if it makes it, without this information, if it makes it to the Office of Hearing and Appeals and they don't have the information about who the heirs are and who's in the will and that sort of thing, there may be a lengthy notification process where they send out multiple requests for people to reply. And if they don't reply, and often people don't, I mean, who does? I mean, unfortunately, I am no better, and I'm an attorney. When my mom's land was probated, I don't think I even answered the BIA. I figured, oh, they got it all right. It's no big deal. So, I mean, that was kind of crazy to do that, but it was a little overwhelming at the time. So if you can just respond quickly and they get the will, then I think I did send the will to them. But, respond quickly and it'll go quickly.
Let's see. You kind of mentioned some things that could get hectic. What are some of the dangers in writing my will or in getting a will drafted that I should be careful of? For instance, we work with well-qualified attorneys, but if somebody were to show up in an attorney, what are some of the things that they should be knowledgeable about? For instance, joint tenancy, right of survivorship is one issue that has come up at some of our outreach sessions versus tenancy in common. Are there dangers that you guys would recommend or issues within their ownership structure that they should pay close attention to?
I think understanding, what has struck me in doing this work is the misunderstanding of what people actually own. When you get that, even people who regularly get ITI reports, they see 80 acres and they think they own 80 acres, not just less than, a small percentage of 1%. Once that is kind of cleared up and they understand that, a lot of times they're like, well, that isn't going to do anybody any good. It becomes clearer what they want to do with that land. And they're more willing to consolidate it or give it back to the tribe because it's like, well, I worried about this my whole life. If I had understood this, I might have done something different. And so, just understanding that. And so one of the dangers, I think, in going to somebody who is not familiar with APRA and those ITI reports, or even asks for the ITI reports, is that land will be, it will go, because of APRA, it will go somewhere unintended, or there's a misunderstanding of what you actually own. So that's kind of the big danger, I would say. And then I'll explain that a little bit. Joint, you can own land with another person in different ways under the law. You can, and in how it passes, so if you own something together with a co-owner, how you own it will determine who it passes to on your death. So if you have a joint ownership with rights of survivorship, that means that you as an individual have no right to pass that on to whoever you want. The surviving owner will inherit it. So if you have 3 kids and you give it to them equally as joint owners with rights of survivorship, the last to pass away will be the one that has the right to pass it to somebody, not the other 2, because the interest consolidates. as opposed to tenants in common, where that your children individually are able to pass their undivided share to whoever they want. And so that's part of the fractionation problem, is that tenants in common problem. So, I think understanding the ownership and, how useful it'll be to the next generation, or if they just have to worry about it, I think is helpful in deciding where they may want the land to go.
Yeah, and we spend a lot of time with our clients discussing the types of ownership and making sure they understand what they're wanting to happen is actually getting effectuated in the document using, the legal terminology. We encounter quite a bit, actually, clients that want to, for example, give one child a house that is located on trust property, but a different child the actual land located underneath it. And we actually experience this quite a bit. And so all kinds of conflicts, that you can just from common sense can arise if you've got, someone different owning, the house located on the property and someone owning the land underneath. And so, we have to spend a lot of time kind of just advising clients on ultimate outcomes, results that could happen in, planning in that way. Jim, you said, working with an attorney, what are some issues that you come across? And frankly, what I would say first is please make sure you're working with an attorney when you are doing, or a legal clinic or someone when you're planning and trying to do a will for your Indian property. I've seen too many, pre-printed forms off the internet or handwritten documents that, like Heidi said, they don't comply with APRA. And so, unfortunately, the consequences of that are maybe that family members get left out, or other people that you wanted to take don't, and people that maybe you didn't want to take will. So it's really important. And we just encourage people, if you have questions, contact an attorney, call us at the clinic. We're more than happy to help and answer whatever questions people may have.
And the scenario I'm referring to actually came up during one of my community presentations, and I'm sure the mother was pleased, and I would applaud her for having an attorney write her will, but whomever drafted it must not have understood the nuances of the American Indian Probate Reform Act. The family was quite clear that the land went to each of her children in equal shares, and that was the end of the sentence. Because she did not address this issue, the law requires the administrative law judge to then give it to each of the children as joint tenants with right of survivorship. And that was only uncovered about a year later when one of her children went to write a will for his children. And the attorney did know APRA and informed him, well, I can't do that for you. So
Right.
it is something to be aware
so
of.
That's right. It is often at least in private practice here in Oklahoma, whenever you are drafting wills for clients and they have nothing to do with Indian property, they're kind of just generalized, to my children in equal shares. And there's no specific indication of how that ownership is going to be structured. And like you said, APRA, if it's silent, then APRA is going to presume joint tenancy. And so, yeah, that's absolutely right. And we've had clients come through with that same, situation happening, where they're asking questions about why, certain people own certain things, and we've had to kind of dig back in the history and figure out, and it's been, similar circumstances.
So with that, I've got a couple more questions as time is wrapping up. What are some nightmare situations that you may have been asked to fix because the Indian landowner did not have a will?
Oh, it's always, that single heir rule, why is it my sister the only one that inherited, or something to that effect? That's oftentimes there's questions as to. We also have a big issue that we have a lot are married couples that don't get divorced, and so surviving spouse sometimes ends up being able to claim a share. And so it's either parent didn't have a will, and so the interest, is distributed under the APRA intestacy provisions, and maybe it's those small fractional pieces, and so only the oldest child ended up inheriting, and siblings have questions about that. And then, sometimes surviving spouses that, when there's no divorces, stand to, take part of that property as well.
I think an additional problem is that probate is not time to find out that there is an odd child that was born outside of wedlock. That really, is an issue not only for land ownership, but other ownership of things, particularly if the individual does not have a will. Then a child that might not necessarily be part of the family is all of a sudden inheriting stuff, and that is not an ideal situation.
Or even if they do have
the second thing is that this leasing issue on tribes, boy, that a lot of work needs to be done on a tribal level, because it's like the Wild West in that scenario about how to straighten out some lease issues. There isn't a lease issue that I've become involved in that wasn't more complicated than you can imagine. And there really is particularly if you have like a Section 184 loan on them, what do you do with that when it's 2 generations back where the ownership is, and it hasn't been probated, and you have only enrolled members can inherit, and only the tribe can buy, and there's a mortgage outstanding. It's just enormously complicated. So, more ownership and probates that tribes can do, I think the better off individuals are, because these answers are complex, and there aren't easy answers to them.
Thank you. I've got one more question, and then if we have a few minutes, there's one topic that is closely related to estate planning, but is not kind of a standard issue. The last question is, how do you address cultural taboos or other resistance to folks tackling their will? Is this something that you have strategies to address, or are you kind of stuck until somebody comes to you?
We are our clients sign up. And so, really they've already taken that initial step to get their documents done. We often encounter, they'll sign up and we won't hear from them again. But to be honest, really with the pandemic, we have seen much higher levels of participation. People are really wanting to get their documents done. They are driving, several hours to come and get their documents executed. So, of all things that have happened in this last year, I think the pandemic has really encouraged people, cultural taboos aside, that this is something that's necessary and we need to get it done, because there have been a lot of death, and families are seeing what happens when their loved ones pass away without a document, without a will. And so they have been more apt and more inclined to call us and really make it happen.
I think to add to what Emily has said, I think that even 10 years ago, there was more hesitancy than there is now. I think more people, with the advent of casinos, comes different problems. And so you have people for, the first time having things that actually that require something more than just, a traditional way of distributing the property. And so I think there's less hesitancy because many people have seen what happens to families when there isn't some planning done, and people are not wanting that to happen. I think that is more what drives people to want to take care of things, or you hear about how did my stepmother get all the property, all that sort of thing, because there was no planning. All those kind of nightmares are kind of driving more estate planning.
Okay, and I'm trying to recall. One of Emily's partners is actually better versed to address. In the background, they were wondering about family trusts for management of trust lands. Is that something that you guys have heard of or have done very much with?
So it's my understanding that and it's been our practice that we don't put trust property into any sort of private trust. It's already in trust managed by the federal government. Is that what you're meaning, private trusts for management? Or
Well, she may be referring to a project that we're working on here at the Indian Land Tenure Foundation. And your colleague, Casey, has actually been one of our primary researchers. She's mentioning that we've been working with families at Umatilla on that project. So specifically, the Indian Land Tenure Foundation has looked at what tools and options are available for estate plans outside of Indian country to see what tools and resources we should be bringing to our own people. And so we had been looking at a couple of pieces. The American Indian Probate Reform Act did provide an opportunity for the Secretary of Interior to put together rules and allow for people to manage their land as uh, as through a corporate entity, but there are a number of problems with that. And again, if you're looking at brothers and sisters who might be co-owners on a non-Indian property that is involved with agricultural activity, it's certainly very easy for them to create a corporation or a family trust under state law, and that entity becomes the landowner of record. And so the Indian Land Tenure Foundation has found that that would be uh, discriminatory against Indians because of what you're talking about, Emily, the trust, the fiduciary responsibility. How do you put a trust within a trust? But our perspective has generally been that people put trusts and corporations within other trusts and corporations all the time, just not inside the Department of Interior and not as it relates to Indian people and that trust relationship over lands within the reservations. And so at some point, we would like to see that resolved because, again, in my personal estimation, that's discriminatory against Indian people in giving them resources to help address things like estate planning. Taxation has been less of an issue, except for the fact that as an individual, if I own my land, any income I derive from that land through agricultural activities is not a taxable event specifically to the state and most of the time under federal law. But if my corporation or my family trust happens to be the operator, they have to have a lease and they have to do a number of other things that takes us, again, I save this toward the end because it goes beyond simple estate plans and simple wills, but it is a tool and resource that people should begin to learn more about. And if there is interest in today or from anyone who views this video in the future, you can certainly contact the Indian Land Tenure Foundation. So this time it's for everyone. Says there is no land title records office in that location, no deeds for improvement. So family trust was felt as a way that they may better manage their matters associated with their fractionally owned Indian trust land. So we're nearing the end. I want to certainly give my thanks to both Emily and to Heidi. Is there anything else that I didn't ask about or anything else that you think that we should share with those who see this video as it regards in estate plans or wills? Open floor for you guys.
One thing I will say, and Heidi kind of touched on this when she mentioned the transfer on death deeds earlier, because we work with individuals who have interests in both trust property as well as their own personal, property that wouldn't be considered Indian property, that would be governed by APRA and go through a federal probate process. It would be governed by a state court probate. So we often, you have people who, if they don't plan or plan correctly, they are at their death looking at potentially having a dual probate, both of their trust property within the BIA as well as a private probate through state district court. And so whenever they seek out the help of a clinic, an attorney, someone that can help plan, you can both plan for that non-Indian property, personal property, any kind of cars, other real property that you own that is not considered trust property that the BIA will not probate. You can take care of that and ensure that that is going to pass outside of a state court probate, so that your family isn't tasked with this dual probate issue at your death. Bank accounts, things like that, making your bank accounts payable on death, and taking care of those things so that, the one thing that is certain is that your trust property is going to have to be probated. But if we can plan and help eliminate the need to do that, federal and state court process, I think that's an important thing to point out for clients. So it's not just about being able to probate, it's about, probating as efficiently as possible.
Heidi, any last comments or words you'd like to share?
Thank you very much for inviting me.
Yes, thank you.
You're very welcome. I appreciate the two of you for sharing your wisdom with us this afternoon. Well, that wraps up. As I mentioned, the next town hall will be June 22nd, again on a Tuesday, and the subject matter will cover appraisals.